Hi, I'm Richard Nemeth. I'm a consumer and small business bankruptcy attorney in Cleveland, Ohio. Today I want to talk about whether or not you'll lose business assets if you file bankruptcy. Many of our clients have small businesses that they'd like to keep operating after they file bankruptcy. So a question that's frequently asked of us is whether or not they'll be able to do that or if they'll lose their business if they file bankruptcy. Under normal circumstances, the answer is that you can keep your business if you file bankruptcy. The main two issues are, one, whether or not the business is a sole proprietorship versus an LLC or a corporation, and two, whether or not the business has significant assets. When a bankruptcy case is filed, property that is owned by the person filing the bankruptcy becomes part of what we call the bankruptcy estate. That property is subject to what we call administration by the bankruptcy trustee, which means that if the property is not covered by a law which says that the property is off limits to the trustee, then it has to be turned over for distribution to creditors. So for example, in a sole proprietorship, a person that had a significant amount of inventory or accounts receivable may have a problem because these are assets that can be taken by the bankruptcy trustee and given to creditors. If the inventory is taken and or if the accounts receivable are collected and turned over to the creditors, it may be difficult for the debtor to continue to operate the business. On the other hand, if the business is a corporation or an LLC, then the business assets do not become part of the bankruptcy estate because they're not owned by the person filing bankruptcy. They're owned by the corporation or by the LLC, which are separate legal entities under the law, just like another person. So the only business property that becomes property of the bankruptcy estate in these circumstances are the corporate shares themselves or the membership interest in the LLC owned by the person that files the bankruptcy. Now, a trustee could conceivably be able to administer shares in a corporation or a membership interest in an LLC, but that's very rare. The analysis goes something like this. Since it is only the shares that are owned by the debtor, the question is, how much money can a bankruptcy trustee get when he sells the shares? This involves a hypothetical analysis of what happens when the business is terminated and the assets of the business sold. Once the assets are sold, the debts of the business must be paid before a distribution can be made to the owners or the shareholders, which in this case would be the trustee. So a good way to look at that is this. If you sold the assets of your business and paid all of the debts of the business, how much leftover money would you be able to put in your pocket? If the answer is little or none, then there would be no reason for the trustee to sell any of the assets of the business. The bottom line is this. Most of the time you can keep a small business if you file bankruptcy, and you can continue to operate that business, but there might be some strategy involved in order to make it work. Ask us for our pamphlet about keeping a small business when you file bankruptcy. It contains more information about the strategies that we use to do this.